I came to pick up my daughter and my ex told me her ex was moving in and there was no discussion. So I said, then neither is the court date. The hallway smelled different. Not perfume, not cleaning spray. Something heavier. Male cologne layered over our daughter's strawberry shampoo. 2 duffel bags sat against the wall near the shoe rack. Black. Zippers half open. A pair of men's boots I did not recognize were placed carefully beside Sadie's pink sneakers. Dana stood in the doorway before I could knock twice. You are early, she said. It was 6:58 p.m. Exchange time was 7 o'clock. I am on time, I answered. She did not step aside. He is moving in. It is temporary. Do not start. There was no build-up, no preface, just a declaration. Behind her, I saw the spare bedroom door open. A shadow moved past the frame. Slow. Deliberate. When did you decide this? I asked. Earlier today. He does not have anywhere to go. We are adults. Be mature. Be mature. That word again. It always meant comply. Is he sleeping here while Sadie is here? I asked. Obviously, she said. Do not make this dramatic. Sadie appeared at the end of the hallway. She held her stuffed rabbit against her chest. She looked at me. Then she looked back toward the spare room. Her shoulders tightened. Go finish packing your things, Dana told her. Sadie did not move. Go, Dana repeated, sharper this time. The shadow in the spare room stepped closer to the doorway. Chat. Same posture. Same tight smile. He raised a hand like we were at a barbecue instead of a custody exchange. Hey man, it is just temporary. Temporary is not a legal category. I looked at Dana. Our order says material changes in living arrangements require notification and mutual agreement, I said. She rolled her eyes. He is not moving into a war zone. He is staying in the spare room. You did not notify me. I am notifying you now. That was not how it worked. He crouched down in front of Sadie. Are you ready? I asked. She nodded, but her fingers twisted the rabbit's ear until the fabric bent. Mom said, do not make it a big deal, she whispered. I stood up slowly. Then neither is the court date, I said. Dana blinked. You are unbelievable. No, I answered. I am consistent. Chad shifted his weight. You are really going to drag this into court? I am going to document a material change in the child's residence involving an unrelated adult male with a record, I said. The court will decide the rest. Dana's face hardened. You are doing this because you are jealous. If I were jealous, I would argue, I said. I am filing. Silence pressed into the hallway. I took Sadie's backpack. I did not look at Chad again. As I walked to the elevator, Dana called after me. If you do this, you will regret it. Regret is emotional. Paperwork is procedural. Inside the elevator, Sadie leaned against me. Is he staying forever? She asked. No, I said. Nothing is forever when it violates an order. When the doors closed, I opened my phone. I did not text her. I called my attorney. Material change, I said when she answered. Effective today. I did not sleep that night. Not because I missed Dana. Not because I was scared of Chad. I stayed awake because deadlines are real in family court. And I meant to file is not a defense. At 3:14 a.m., I sat at my kitchen table with the custody order printed out, highlighted like a crime scene map. The paper smelled like toner and stale coffee. The words were not dramatic. They were precise. Material change. Notification. Unrelated adult occupant. Child stability. At 7:05 a.m., I dropped Sadie at school. She got out of the car, paused, then said something small that landed hard. Mom told me not to say his name around you, she whispered. My hand tightened on the steering wheel. Did she say why? I asked. She shrugged. Her eyes went to the ground. Because you get serious. I watched her walk to the entrance. Her rabbit was tucked into her backpack like contraband. When I got back to my car, I did not call Dana. I did not warn her. I called attorney Jessica Ham. Emergency motion, I said. Jessica did not ask how I felt. She asked for facts. Timeline. Yesterday at 6:58 p.m., she told me he is moving in. No discussion. Sadie is there during her parenting time. Any written proof? She texted last night. Do not start. It is temporary. Any threats? She said I would regret it. Jessica paused. I heard a keyboard click. Then her tone sharpened. Do you have third-party documentation that he is actually there overnight? That was the hinge. People lie in court. Paper does not. I can get it, I said. I drove straight to Dana's building, not to confront her, to document. Her building was mid-rise, professionally managed, the kind that loved rules and hated surprises. There were cameras at every entrance, a concierge desk, a leasing office that smelled like air freshener and quiet judgment. I introduced myself to the property manager, Miss Medina, with my calmest voice. My name is Kyle Merritt. I was listed as an authorized guest for Unit 1407 during my relationship. I have a child who stays there. I need to confirm whether an additional adult has been residing there overnight. Missus. Medina blinked, already defensive. We cannot release tenant information. I am not asking for tenant information, I said. I am asking for building security footage for a safety matter involving a minor. I can provide the custody order and my identification. I will also submit a formal request through counsel. I slid the papers across the counter. The order. My driver's license. A photo of Sadie. Her posture changed when she saw the word minor. We do not provide footage to individuals, she said, softer now. But we will preserve footage if we receive a request from an attorney or law enforcement. Preserve it, I said. From yesterday at 6 p.m. to 11 p.m. and again overnight from 11 p.m. to 7 a.m. Cameras at the main entrance and the elevator bank. Mrs. Medina hesitated. Then she nodded once. I will flag it. What is the reason you are requesting preservation? Unapproved adult occupant in a unit where a child sleeps, I said. I am filing an emergency motion. She did not ask who. She did not ask why. She asked the only question that mattered. Was your name on the lease? It was, I said. It is not now. Her eyes narrowed, like she could smell conflict even through laminate countertops. We have had issues with that unit recently, she said carefully. Noise complaints. Smoking on the balcony. It started this week. This week, my jaw tightened. I would like a written note stating the building is preserving footage and documenting complaints, I said. We can provide an incident log for the unit, she said, to the tenant or to council with proper authorization. Jessica would handle the authorization. My job was to ensure the data existed when the lies started. I left the leasing office and sat in my car. I did not feel triumphant. I felt focused. I called Jessica again. They will preserve footage, I said. They also mentioned new noise complaints and balcony smoking. Jessica exhaled once. Not really. Approval. Good, she said. We will subpoena footage if necessary. In the emergency filing, we will reference building surveillance as potential corroboration of overnight occupancy. What about psychological evaluation? I asked. That comes after the emergency order, she said. But we can see it now. We will request a temporary order restricting unrelated adult overnight guests and ask the court to appoint a guardian ad litem. See it now. I liked that phrasing. Controlled, surgical. By noon, Jessica had drafted the emergency motion. The language was cold, almost boring, which is exactly how you win. Not, I feel unsafe. Not, I am uncomfortable. Instead, material change in child residence without notice. Unrelated adult overnight presence. Child instructed to conceal information. Potential safety risk pending background review. Request for temporary modification and restrictions. Request for guardian ad litem and home study. I signed the declaration with the same hand I used to sign invoices at work. Steady. Unromantic. At 2:41 p.m., the motion was filed. At 4:10 p.m., Dana texted. Why are you dragging my landlord into this? So she knew. She did not ask about Sadie. She asked about control. I stared at the screen until it dimmed. Then I typed one sentence. You changed Sadie's home without notice. I am documenting it. I did not add punctuation. Punctuation invites conversation. Her reply came fast. You are weaponizing the court because your ego is bruised. I did not respond. At 6:30 p.m., Jessica forwarded me the hearing notice. Emergency hearing. 72 hours. The court would speak, and by then, the cameras would have already recorded who walked through that door and how long they stayed. The footage came in at 9:12 a.m. the next morning. Not to me, to Jessica. She forwarded only a single line first. You need to see this before the hearing. Attached was the incident log from Dana's building. Timestamp. 12:43 a.m. Location. 14th floor hallway. Complaint. Loud male shouting. Profanity. Door impact sound. Child crying heard. My stomach did not drop. It locked. Below the written complaint was a notation from on-site security. Responded to noise disturbance. Male occupant identified as guest. Female tenant stated argument was private. Child visible in hallway briefly. Child visible in hallway. The hallway camera clip was time-stamped down to the second. 12:41:17 a.m. Chat exits Unit 1407. 12:41:26 a.m. He slams the door hard enough to shake the frame. 12:41:31 a.m. His voice echoes. You do not tell me what to do. 12:41:42 a.m. The door opens again. Dana appears, barefoot. 12:41:48 a.m. A small figure stands behind her. Sadi. She steps halfway into the hall. Chad turns back toward the door. Security arrives at 12:43:09. The audio is not cinematic. It is worse. It is flat. Echoed. Real. Sir, we have had complaints, the guard says. Chad's voice is louder than necessary. Defensive. Sharp. Mind your business. Dana cuts in. It is fine. We are fine. Security writes the incident number down on a tablet. At 12:44:32 a.m., the door closes again. Sadi is the last thing visible before the frame freezes. I watched the clip twice. Not because I needed to, because I wanted to feel exactly how angry I was before walking into court. Jessica called at 9:26 a.m. This is sufficient for immediate restriction, she said. We will present the incident log and request temporary physical custody pending evaluation. Do we subpoena the security guard? I asked. Yes, she said. He is listed by name in the report. He is neutral. That helps. The hearing was set for 1:30 p.m. Dana texted at 10:02 a.m. Why is building security asking me questions? I did not respond. At 11:15 a.m., another message. This is harassment. Harassment is when someone follows you. Documentation is when someone records you. I left work early. The courthouse was gray concrete and fluorescent light. It smelled like paper and cold air. Family court does not look dramatic. It looks tired. Dana was already there when I arrived. Chad stood beside her. He did not look defiant now. He looked irritated. Like this was inconvenient. Dana's jaw was tight. She wore a navy blazer she used for corporate events. She wanted to look composed. You subpoenaed my building? She hissed. I requested preservation of footage, I said. You are trying to destroy my life. No, I answered. I am preventing instability in my daughter's life. Chad stepped closer. You are exaggerating, he said. It was one argument. At 12:43 a.m., I replied. With my daughter present. His silence lasted half a second too long. We were called in. Judge Thornton did not smile. Emergency hearings move fast. There is no theater, only compression. Jessica stood, calm. Your Honor, we are requesting temporary modification due to a material change in the child's residence. An unrelated adult male with documented disturbances is now residing overnight without notice to the co-parent. Additionally, the child was instructed to conceal information, and there has been a verified noise incident involving raised male voices at 12:43 a.m. with the child present. She handed over the incident log. The courtroom was quiet enough to hear paper move. Dana's attorney rose. This is an isolated disagreement. The father is weaponizing normal adult conflict. Judge Thornton did not look up. At 12:43 a.m., the judge asked. Dana spoke before her attorney could stop her. It was not like that. The judge's eyes lifted slowly. Then explain what it was like. Dana hesitated. Chad shifted in his seat. It was a misunderstanding, Dana said. He was stressed. And the child? The judge asked. She was asleep. Jessica spoke without raising her voice. The incident report states the child was visible in the hallway during the altercation. Judge Thornton read silently for several seconds. Then, was the child instructed not to inform the other parent of the new adult occupant? Dana's lips parted. That is not relevant, her attorney said. It is directly relevant, the judge replied. The air shifted. Judge Thornton looked at Chad. Sir, do you have any history of alcohol-related offenses? Chad's jaw tightened. That was years ago. That was not my question, the judge said. Yes, Chad answered. Silence again. Family court does not punish drama. It corrects risk. Judge Thornton leaned back slightly. Temporary order, she said. Effective immediately. The minor child will reside primarily with the father, pending full evaluation. The mother's parenting time is restricted. No unrelated adult overnight presence during visitation. Guardian ad litem appointed. Home study ordered. The gavel did not slam. It clicked. Dana's face drained of color. Chad leaned back as if someone had pulled a chair out from under him. I did not smile. I did not feel victorious. I felt alignment. As we exited the courtroom, Dana grabbed my arm. You actually did this? She said, voice low. I looked at her hand until she let go. You said there was no discussion, I replied. Now there is a record. Behind her, Chad walked down the hallway alone. He did not wait for her. Psychological evaluations are not dramatic. There are no shouting matches, no cross-examinations. There is a clipboard, a neutral tone, and long silences that expose more than accusations ever could. Doctor. Cannon scheduled my session first. Her office was minimal. Gray walls. 2 chairs facing each other. A shelf of clinical textbooks arranged with almost surgical precision. She did not ask how angry I was. She asked, describe your co-parenting dynamic in 3 words. Structured. Predictable. Previously functional, I said. She wrote something down. When did it change? When unilateral decisions replaced communication, I answered. Be specific. An unrelated adult male moved into my daughter's residence without prior notice. My daughter was instructed not to inform me. There was a documented altercation at 12:43 a.m. She nodded once. How do you handle conflict? I document. E. De-escalate. E. Involve process. Do you attempt reconciliation before escalation? Yes. I asked questions at the door. I did not argue. E filed. Her eyes stayed on me for a few seconds, longer than necessary. Do you believe the mother is dangerous? No, I said. I believe she is impulsive under stress and prioritizes control over collaboration. That was the most emotional sentence I allowed myself. Doctor. Cannon wrote it down, word for word. The home study followed. She walked through my apartment slowly. Sadie's room was quiet blue. Books stacked in hate order. A calendar on the fridge marked with custody exchanges and school deadlines. Doctor. Cannon observed Sadie at the kitchen table coloring. What happens when you feel worried? She asked Sadie gently. I go to my room, Sadie said. Or I ask Dad. Does Dad tell you to keep secrets? Sadie shook her head immediately. Doctor. Cannon did not react. She only noted. 2 days later, she visited Dana's unit. The hallway camera had already been subpoenaed. The tension in that building was visible even before the door opened. Dana greeted her with a smile that did not reach her eyes. Chad was not present. He had stepped out. Convenient. Doctor. Cannon sat at the dining table. Tell me about your co-parenting relationship, she began. Dana crossed her legs tightly. He is rigid, she said. He escalates small issues. Can you give an example? He filed an emergency motion because I helped someone. Why did you not inform him beforehand? Dana hesitated. Because he overreacts. Is that your determination alone? Doctor, Cannon asked. I know him. Did you consider that introducing a new adult into the child's home might require collaborative discussion? Dana's tone sharpened. I do not need permission to live my life. Doctor. Cannon remained still. This is not about permission, she said. It is about co-parenting insight. Dana's jaw tightened. He cannot control who I date. Correct. Doctor, Cannon replied. But joint legal custody requires shared major decisions impacting the child's environment. Silence stretched across the room. Do you believe asking the child to withhold information was appropriate? Doctor, Cannon asked. Dana exhaled through her nose. It would have caused conflict. With whom? Doctor, Cannon asked. With him. Not with the child? That question lingered. Dana looked away first. The home environment review was clinical. The spare room contained Chad's clothing, shoes lined near the closet, a toothbrush on the bathroom sink. Not temporary. Doctor. Canon made no comment, but she measured. On the way out, she paused. How do you resolve disagreements with the father? She asked one final time. Dana's response came without reflection. I do what is best. He adapts. Doctor. Canon closed her folder softly. So parenting is not a hierarchy, she said. 3 weeks later, the evaluation report was filed with the court. Jessica forwarded it to me without commentary. The language was restrained, professional, devastating. Mother demonstrates high conflict decision-making pattern. Limited co-parenting insight regarding shared legal custody obligations. Tendency toward unilateral action without collaborative consultation. Child exposed to adult relational conflict during late-night incident. Recommendation. Structured custody with primary physical residence remaining with father, pending demonstrated behavioral adjustment. I read it twice. There was no insult in it, no moral judgment, just pattern recognition. Dana called that evening from a blocked number. You turned a therapist against me, she said. No, I replied. You spoke. This is not fair. Fair is irrelevant, I said. Documented is relevant. She was quiet for a moment. You think you won. I think Sadie sleeps through the night, I answered. When the call ended, I looked at the calendar on my wall. The final review hearing was 2 weeks away. And for the first time since that hallway confrontation, I felt something colder than anger. I felt inevitability. Final review hearings do not last long. By the time you reach them, the story has already been written in reports, logs, and patterns. The courtroom was quieter than before. Dana did not stand close to Chad this time. Chad was not even inside. He waited in the hallway. That told me everything. Judge Thornton had the full file in front of her. Incident log. Camera timestamps. Guardian ab litem notes. Doctor. Canon's evaluation. Temporary compliance records. Paper does not get emotional. It accumulates. Jessica spoke first. Your Honor, since the temporary order, the child has remained stable in the father's residence. School attendance consistent. No additional behavioral concerns. The mother has complied with restricted visitation, but has not demonstrated meaningful co-parenting insight in sessions. The judge nodded once. Dana's attorney stood. The mother loves her child. This was a relationship misunderstanding that escalated. The judge looked at Dana directly. Do you understand why your unilateral decision triggered court intervention? This was the moment. Not dramatic, not loud, just a question. Dana inhaled. He overreacted, she said. The courtroom air shifted slightly. The judge did not blink. Even after the incident at 12:43 a.m.? That was one argument, Dana replied. And instructing the child to withhold information? Dana's lips pressed thin. I did not want conflict. Judge Thornton closed the file gently. Joint legal custody requires cooperative decision-making, she said, not post-fact notification. Silence. The judge continued. The court finds a demonstrated pattern of high-conflict unilateral decision-making. The child was exposed to adult altercation during late hours. The mother has shown limited insight into the impact of these actions. Here was no anger in her tone, just resolution. Effective immediately, she said. The father is awarded permanent primary physical custody. The mother will receive structured visitation contingent upon continued counseling and compliance with court-ordered co-parenting education. Joint legal custody remains, but major residential changes require documented mutual consent. The words landed clean. Permanent. Dana's shoulders stiffened. For the first time since this began, she did not argue. She did not accuse me. She did not look at Chad. She stared at the bench as if the bench had betrayed her. The gavel clicked. That was it. No explosion, no dramatic music. Just a custody order signed and entered into record. Outside the courtroom, Dana approached slowly. You destroyed everything, she said quietly. I did not respond immediately. I enforced a boundary, I said. You could have talked to me. I did, I replied. At your doorway. Her eyes flickered. Not anger now. Something else. Recognition, maybe. Chad passed by us without stopping. He did not meet her eyes. He did not meet mine. Temporary had ended. That evening, Sadie ate dinner at my kitchen table. She did not twist her rabbit's ear. She did not whisper. She asked if we could plant something on the balcony for spring. Yes, I said. Routine is quiet. Stability is quiet. Non-negotiable is quiet. 2 weeks later, Dana sent a formal request through council to modify her visitation schedule. This time, it included the phrase subject to mutual agreement. Paperwork changes people, sometimes faster than apologies. I do not hate her.
I do not celebrate.
Family court does not feel like winning. It feels like correction. When someone tells you there is no discussion in a shared life involving a child, the discussion is already over. You just decide where it happens next. For me, it happened in front of a judge. And now, Sadie sleeps through the night. That is the only metric that matters.